understanding the spending power. So to explain this, we should start, as we always do, with the text of the Constitution. So the very first provision of Article 1, Section 8, the very first one, open up your constitutions if you don't have it, you should have it. The very first provision of Article 1 spells it out. It says, the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. Okay. All right. What did I finish last time? You're up next? Okay. So, Kiara, tell me, please. What can Congress do just under the text of the spending clause? I'm sorry, the taxing clause. What can they actually do? Good. And once they impose that tax and all this money comes flowing into the nation's capital, what can they do with that money? Where does it say in the Constitution, Kiara, that Congress can spend money? Doesn't. So this is actually one of the biggest conundrums of constitutional law. You will often hear people speak of the spending clause. If you open up any commercial outline, they'll say the spending power. Yet, there's no actual provision in the Constitution, none, that says Congress can spend money. They say Congress can raise armies, Congress can make post roads, Congress can do this, they can do that, but there's nothing saying what Congress can spend on. And because the Constitution is silent over what Congress can spend on, there was a massive debate throughout really the first 2 centuries of our republic about what Congress can spend money on. Can Congress spend money only on the things they have the power to accomplish? Or can Congress spend money on whatever promotes the general welfare? A similar argument was made at the taxing power. Are there some things Congress can and cannot tax? Can Congress only tax people for things they're allowed to regulate? Or can Congress simply tax people to raise money to promote the general welfare? So this simple clause of the Constitution has given rise to extensive and massive debates over what is Congress's power to tax and what is Congress's power to spend. These seem like simple aspects of what our government can do. Yet the Constitution is silent on this pivotal question. Okay? So any questions on that? All right, David, tell me please, sir. What is the purpose of taxes? What is the purpose of taxes? In general, not just this class. What's the purpose of taxes?
To just keep the economy going.
How? What?
We pay taxes. It goes back. Of course, those are taxes imposed on us by Congress, and that's money that helps the government to just or help.
So it's funds. It raises money.
Mm-hmm.
David, is that the only reason why we have taxes?
No, but also to, of course, help out when it comes to the common, like providing for the common defense.
Have you ever bought a item of alcohol?
Yeah.
What is the? Yeah, that's fine. When you bought that item of alcohol, was the cost high?
The taxes on it was high.
The taxes, why? So we have a usual sales tax, right?
Mm-hmm.
But there are special taxes on booze, aren't there? Why did the state impose special taxes on alcohol?
The policy behind it is to, well, I think there are 2 different policies. But the first, one of the policies was to be able to regulate the way that alcohol is consumed or who consumes it.
Right. Right. So Anna, let me ask you a question. When the government puts a tax on, say, cigarettes or a tax on alcohol, which no one's ever used in this room, any of those products, right? Why do you think, Anna, the government puts a tax on things like alcohol, cigarettes, wages you may earn from gambling? Why do you think there's special taxes on these sorts of items?
To discourage everything.
Exactly. So really, there are two main reasons why governments impose taxes, right? One, of course, Davian said it, is to raise revenue, to fund the government and all that it does. But taxes can also take on a regulatory function. Taxes can take on a regulatory function by imposing what could be called a sin tax, right? A tax on something deemed sinful, tobacco, alcohol, whatever you want. You're hoping to discourage people. If you make the price of cigarettes $25 a pack, well, people may not smoke as much. You make the price of alcohol having this massive whiskey tax on it, people may make their moonshine, right? Like in Beaumont. There it is, right? We talked about this the other at the terrorist party, apparently. He makes his moonshine. So, taxes serve both functions. So the question becomes this, right? Let's see, that's Delaney. Is there anything in the Constitution that says Congress can only tax to raise money, whereas Congress can't tax to, regulate and to discourage certain activities? Is there anything in the text of the Constitution saying one way or the other? No. Okay. So the Constitution is silent about what function taxation can impose. It's silent. So now Congress has an opportunity. For the first 140 years of our republic, the Commerce Clause was understood that Congress can only regulate stuff that goes between states, right? That was the general understanding of the Commerce Clause. So if Congress couldn't regulate stuff going between states, John, what else could Congress do to go after stuff within one state only?
Tax it.
They can tax it. John, can Congress tax stuff within one state that would not otherwise be able to be regulated under the Commerce Clause?
Yes.
Why?
Because it's broader than the Commerce Clause.
Bingo. So the magic lesson of the tax clause cases, and the Supreme Court recognized this in the 1866 license tax case, is that taxing power is broader than the commerce power. The taxing power is broader than the commerce power, right? Samuel, what does that mean that the taxing power is broader than the commerce power? What am I saying here?
That the limits placed on it are broader, easier to fall into. I think the main limitation being as long as it's equal.
Yeah. Samuel, let me ask you this follow-up question. So before the New Deal, did Congress regulate the sale of alcohol within one state? Before the New Deal, Congress could not regulate the sale of alcohol within one state. Could they impose a federal whiskey tax?
Yes.
Even if the alcohol never crossed state lines? Yes. And that's a lesson of the 1866 license tax case. The court upheld a tax on lottery tickets and liquor, even if it was only within one state, even if the liquor never crossed state lines. Okay? And this is important because with this case, Congress now had the power to tax stuff they couldn't regulate. Keep this lesson in mind when you do the Obamacare case next week of why the court was able to uphold the individual mandate as a tax, even though it was not a valid regulation on commerce. This was actually the crux of the entire Obamacare case that most law students never paid attention to, but fortunately you will. Okay? So with this rule then, Congress doesn't need to tax stuff out of existence. I'm sorry, Congress doesn't need to regulate stuff out of existence within one state. They can simply tax it out of existence. So you have the license tax case. You have the other case, VZ Bank versus Feno, which upheld a federal tax on state banknotes. Again, taxes of stuff within one state is within Congress's power. And then we go to the 1904 case of McRae versus United States. often called the oleomargarine case. Now, this may be a history unfamiliar to you, but margarine, right? Everyone know what margarine is. It's like basically a butter substitute made from vegetable oil, right? Margarine posed an existential threat to America's dairy farmers, right? Why? Because you no longer needed milk to make butter. And unsurprisingly, dairy farmers used the full weight of the milk lobby, and there is such a thing, to try and shut down margarine producers. States actually passed laws, I'm not joking you, that banned margarine. States actually enacted laws requiring margarine to be dyed pink, right? Margarine is basically yellow. It's the same color as butter. You probably can't even tell the difference by looking at it. States mandated that you dye margarine pink. And we want to put like a pink thing on a piece of bread? No, it looks gross. They tried their best to do it. And in the case of United States versus McRae, Congress actually posed a tax on margarine, right? Margarine created in one state, it's probably much easier and cheaper to produce than butter, but the court upheld the tax, okay? Pivotally, so Antonique, was there any guessing that this idea, that this tax on this tax on margarine was meant to raise money? Was that even like a thought? Why was this tax imposed on the margarine? For one reason only. Yes, out of business. The sole purpose of this tax was to basically regulate the industry out of business, to make it so expensive to make this margarine. And when you go to the grocery store, you see a thing of butter for $1, and the thing of margarine has like a $2 tax on it. Well, you know how you're gonna shop.
But isn't that healthier for you even better?
So this is actually really funny. I'm so glad you mentioned that, right? At the time, the dairy lobby made all these arguments about how margarine was unhealthy and how actually butter was good for you. And in hindsight, we know that the actual butter is much worse for you. I'll give you one other one. So does anyone know about filled milk? Anyone know what this is? Condensed milk is also called. Okay. So condensed milk is effectively you take milk and you boil it to remove the dairy, and you fill it with like coconut oil or vegetable oil, right? This way you could actually put milk in a can and can sit on a shelf. It doesn't require refrigeration. Okay, this was a revolution for people who were too poor to afford electricity. They could actually keep, the condensed milk in a can. The dairy farmers came out with all this bogus science saying how this condensed milk was bad for you, right? That it was going to make you sick. It was all bogus science. And on this basis, Congress banned condensed milk. Congress banned condensed milk. We'll do this case. It's called United States versus Caroline Products. We'll do that in a couple weeks. But the funny part is, in the 1970s, finally, a federal judge in Illinois said, you know what? This ban on filled milk is irrational. It makes no sense. One of the reasons why, the filled milk is healthier, right? The condensed milk is healthier than the dairy milk because there's less cholesterol. So Antonique is on the exact right track. These are all fake science. They made this bogus science to put these healthier industries out of business. It happens all the time. Companies use their market forces to enact laws that are beneficial to their industries by making stuff up and saying the competitor is dangerous for you. There's nothing new about that. But she's exactly right. Okay. So in the margarine case, said, listen, the remedy for this abuse of the taxing power is a political process. It's not for the courts to second guess if the legislature wants to impose a stupid tax. Vote the bums out, as they say. Although the dairy lobby was very powerful, and they kept their they had their Congress by the udders, so to speak. All right. Any questions in that case? Don't get myself in trouble. I forget they're there. All right. So now we move though on to a change, right? We move on to a change in 1922. And there's actually a case we mentioned before. We discussed the case last week of Hammer versus Dagenhart. Hammer versus Dagenhart. And you recall in that case, Congress tried to ban manufacturing with child labor. Congress tried to ban manufacturing with child labor. And you recall the court said, wait a minute, you can't do this. This is unconstitutional. Manufacturing is not commerce. And because manufacturing is not commerce, Congress lacks the power to prohibit child labor manufacturing. So what did Congress do next? Said, wait a minute. We learned this in ConLaw. our taxing power is more broad than our commerce power. So if we couldn't regulate child labor with our commerce power, boom, we will use our taxing power. So instead of simply banning child labor, they impose a 10% tax on the profits from the sale of goods made with child labor, a 10% tax. Right? Now, Paul, what do you think the consequence would be for any business that was subject to a 10% tax of profits?
Not good.
Yeah, what would happen to them?
They go out of business.
They go out of business, right? Most businesses don't have very high profit margins. I think Walmart, for example, tries to keep their profit margin around 11 or 12%, right? Their markup is roughly 10 or 11% above the price they pay for it. That's how they keep their prices fairly low. If there's a 10% profit tax, it basically wipes out your entire business. So Zach, is there an actual difference then between a regulation of commerce banning child labor and a 10% tax on child labor? Is there any meaningful difference in the outcome?
No, not really.
What happens in both situations?
Child labor fails.
And they go out of business.
They go out of business.
So this case went to the Supreme Court, right? The case was called Bailey versus Drexel Furniture. It's often called the child labor tax case as an abbreviation. And the court says, like, wait a minute. You guys, Congress, you're not going to fool us here. We know what you're trying to do. You tried to ban child labor for the commerce power. We said no. You went back and tried to frame this regulation as a tax. No. And here's the pivotal portion. By the way, every law student in the country was taught that this case was bad law. Every law student was taught that this case was bad law. It's this pre-New Deal jurisprudence. This was the foundation of the Chief Justice's Obamacare decision. You will see this next week. Everyone thought this case was bad law. We can't cite it. Still good law. So ignore Westlaw for whatever you will. It was perfectly good law. It's never overturned. So the court said, listen, you can't accomplish through the taxing power what we told you cannot do through the commerce power. You cannot use the taxing power as a shortcut, right? You can't regulate manufacturing, and you can't pretend to do the same thing through the taxing power, right? Indeed, the court says this was not an actual tax. This was a penalty. Oh, now it clicks, right? This was not a tax. This was a regulatory penalty. They were only pretending to use the taxing power. This was nothing more than a regulation on domestic commerce. And under the law at the time, Congress could not regulate that under the commerce power. They can now, but at the time they could not, right? Therefore, this was an improper penalty. It was not a tax. The court said the tax loses its character. It becomes a mere penalty when it's about regulation and punishment. This was not about raising funds. This was about punishment and regulation. Okay. So Bailey, again, everyone thought this was bad law. As you'll see in NFIB next week, it's not bad law. Apparently, this part was still good law. So in Bailey, at least, the court was saying when the tax becomes punitive, it becomes a penalty. That's an attribute of the commerce power. And because this is not regulated by the Commerce Clause, Congress cannot do it. The court struck down the child labor tax. Everyone with me so far? Any questions on Bailey? Okay. But then 1937 happened. The New Deal happened. Roosevelt's court packing plan happened. And like with so much of constitutional law, in the blink of an eye, the court pivoted and changed direction. So one of the most prominent New Deal programs is one you know about today, which is called Social Security. And there are different aspects of Social Security. One of the aspects is a tax on employers. If any of you have ever worked, I hope you all will one day. your employer actually is required to pay a percentage tax to the Social Security trust fund black box, whatever it is, lockbox. The other aspect is Social Security encourages states to set up unemployment programs for the states. The question was, could Congress do this? Okay, so now there's actually a funny story. I wrote about this in my first book, where President Roosevelt's Secretary of Labor, her name was Frances Perkins, one of the first female cabinet officers. She was considering how they would enact this new bill that would become known as Social Security. And they were very scared because they said, wait a minute, we can't require local businesses to pay this tax under the Commerce Clause. How are we going to, how are we going to require these local businesses to pay this fee? And there's a story which she herself told. It may be true, maybe not, but she told it. So Perkins says she was at a tea party with Justice Stone, Harlan Fiske Stone. And she goes, Mr. Justice, I'm very worried that the court will invalidate our program. Imagine this, right? A cabinet official telling a justice, I'm worried the court's going to invalidate this federal law. And Justice Stone, as the story goes, said, my dear, lean in. And he whispers in her ear, all you need is a taxing power. Don't worry about regulating commerce. Frame it as a tax. And that's precisely what the Roosevelt administration did. They framed Social Security not as a regulation of local businesses. They framed Social Security as a tax. And as we saw in the license tax case, because the taxing power was broader, they were able to get after activity that was within one state only. Okay. And the main case was called Stewart Machine Company versus Davis. And there was another case called Helvering versus Davis. I actually found a picture. Oh, I'm sorry. This was actually a picture of the Drexel Furniture Company in North Carolina, where all those children worked. It looks very, that's rustic. This is a Stewart Machine Company in Birmingham, Alabama, and they were one of the groups that challenged the tax. This is a group of workers at the Stewart Machine Company. I think it's from 1900, but the date is rather blurry, so I couldn't get the exact date. And here are some of the kids working there. And actually, Stewart Machine Company is still in business, which go figure. I'm assuming the shareholders haven't taken constitutional law because they have some of a bad rap in the casebook. But they were one of the ones who challenged this program. So I'll go back to this picture. So they challenged the Social Security tax, and the court upheld it, saying, look, this is not a regulation of commerce. This is merely a tax. The states aren't being required to do anything. They are merely having some incentives to act. So Social Security was upheld as a tax. And this was another one of the significant 1937 cases where the court more or less told FDR, you win. And that's the settlement that we have till today. So under the taxing power, Congress can more or less tax for whatever purpose they wish. With the caveat of the child labor tax case, if the tax becomes punitive, it may no longer be a tax, it will be deemed a penalty, which is unconstitutional under the Commerce Clause. You'll see that next week when we do the Obamacare case. Most people gloss over the taxing power case. For all the NFIB v. Sebelius debate, it all came down to the taxing power, which surprised everyone, myself included. All right, so any other questions on the taxing power? Yes, sir.
So where does it say in the Constitution that Congress can penalize?
Well, under the Commerce Clause, right? Under the Commerce Clause, Congress can enact a regulatory regime. And if you fail to comply with it, they can penalize you for doing so.
But I thought you were just going to use it as a Commerce Clause.
Well, let's say it was. Like, for example, John, let's say that Congress passes a law saying that all railroads going between New York and New Jersey are required to provide a certain accommodation to passengers, right? And then say some railroad going between New York and New Jersey does not provide those accommodations. Congress can then penalize them under the Necessary and Proper Clause and the Commerce Clause, right? In order to effectuate their commerce regulation, they can penalize people who don't comply. Does that make sense?
Yeah. I thought it was something different.
No, the power to penalize comes from the Commerce Clause. But if it's something Congress cannot regulate under the Commerce Clause, they can't penalize it, right? This is what happened with the Affordable Care Act. The court held that Congress cannot regulate inactivity, right? Congress cannot regulate inactivity. Therefore, Congress can't penalize you for being inactive. They can, however, tax you for being inactive. And that's the entire crux of the Chief Justice's opinion.
So is the tax and hammer seen as punitive because it's just
Bailey. Hammer was the Commerce Place. Bailey versus Drexel Furniture.
Okay, I'm sorry. Was
Yeah.
the 10% seen as punitive because it's so substantial to their entire business, or would any extra tax?
Okay, so this is interesting. So what's the line between a regulatory penalty? What's the line between a permissible tax and a punitive penalty, right? Read Chief Justice Roberts' decision. And to put this in terms of Obamacare, which is perhaps easier to grasp, under the Affordable Care Act, for example, the size of the penalty is actually capped. The size of the penalty can never be more than the average price of health insurance. I'm simplifying, right? So imagine you had a situation like this. The penalty, say, was $5,000, and the cost of having insurance, say, $1,000. Would anyone pay $5,000 for a penalty when you can get an insurance policy for cheaper? So what the chief said is, so long as the price is less than the average cost of insurance, it's not punitive yet. That's why the court was able to hold it as a tax. I've actually written about this otherwise. If, for whatever reason in the future, Congress tries to raise the Affordable Care Act's penalty, I think it's no longer can be saved as a tax. It becomes unconstitutional. But that was one of the things that were in my first book. But there's a cap of when it becomes too punitive. It's vague, but there's a cap. Questions on the taxing power? No? Okay, I'll move on. So the next topic I want to discuss is the spending power. Okay? Spending power. And as we go back to the text of the Constitution, we see that, again, there is no actual spending power. There's none. Congress can pay debts, they can provide for the common defense and general welfare, but there's no actual provision in the Constitution that says Congress can spend money on X. So from the earliest days of our republic, right, we're sitting here in year 2016 arguing about the Constitution. Oh, yes, sir.
I know it's not explicitly said that you can spend, but if you argue that providing for the general welfare is more like without you can spend.
Well, that's Hamilton's argument. I'll get to about 20 seconds. Okay. So from the earliest days of our republic, the earliest days, a debate ensued. Once again, between James Madison and Alexander Hamilton. Yeah, I was like 15 seconds away from you. I'm almost there. James Madison, a disciple of Thomas Jefferson, favored stronger states' rights and sought to limit the power of the central government. Alexander Hamilton, as always, favored the strong executive and a stronger central government, especially in matters of credit and finance, which was what his greatest contribution to our republic in its early days was. So the debate was this. Hamilton said, just like Felipe said a second ago, wait a minute, it says general welfare there, right? Congress can spend money on whatever it wants so long as it pursues the general welfare. And let's face it, friends, the general welfare means whatever you want it to mean. It's effectively a limitless standard. Okay? In contrast, right? In contrast, James Madison said, no. Congress can only spend money on those enumerated powers listed in Article 1, Section 8. Madison said Congress can only spend money on those powers enumerated in Article 1, Section 8. For example, Congress wants to make a post office, they can spend money building the post office. Congress wants to, establish a bank, they can spend money on the bank. Congress wants to spend money on, building an army, they can spend money on building an army. Okay. Congress can only spend money on those things that were enumerated in the Constitution. Okay. Everyone with me so far? So what's interesting, though, in a case called United States versus Butler, we'll get to the principal cases later. These are the smaller cases. Oh, yes, sir.
That's why I asked one thing, because in Madison's argument, basically saying that it was enumerated powers limited to that, is that because of the necessary and proper clause that he's saying that?
Well, you have to remember that Madison was speaking before McCulloch v. Maryland. Okay. So the actual necessary and proper argument was also of Hamilton, wasn't it? So Madison was under his own very strict understanding of necessary and proper, so it was even smaller than we would argue today. Madison would argue they couldn't even spend money on the bank because the bank was not a necessary and proper incident of the commerce power. So Hamilton, again, for all that we praise James Madison, in terms of whose ideas prevailed in the long term, his name is Alexander Hamilton, to quote the song. I mean, he more or less won the big ones, the big questions. Although we revere Madison, we usually cite Hamilton, for better or for worse. So one of Franklin Roosevelt's biggest policies at issue in the New Deal was called the Agricultural Adjustment Act. Now, in Wickard, you mentioned the 1941 amendments to AAA. The original AAA was passed in 1938. And the Supreme Court initially invalidated it. And I have a couple of political cartoons, which I like showing, where the Supreme Court steps out the Agricultural Adjustment Act, the wise old men. And this was meant as a farm relief bill, and the court invalidated it. And you can see, this is a steamroller, and that says Franklin Roosevelt, let her go, Mr. President. And the holding of signs saying trusted economic laws, businessman, right? That's basically steamrolling the economy. Okay, this one I like too. This is FDR saying, okay, now all together, yes, because he points out the judges who agree with him. So I like this picture the best. So there's a challenge to the Agricultural Adjustment Act, right? And this law effectively paid farmers to grow less. Right? This was what we studied with Wickard. It basically paid farmers to grow less crops. Now, at the time, Congress could not regulate agriculture under the Commerce Clause. They could not. Right? This is before Wickard. They could not regulate agriculture. They could not spend money. So what the court effectively said was, right, this is not something that Congress can spend money on. Okay? This intrudes on the rights of the states. To allow Congress to pay off farmers is intruding on the rights of the states. And there's actually a parable, right? Because if you think about it, on the one hand, Congress could not regulate farmers, but they're trying to do the exact same thing through spending money. So rather than telling farmers what to do, they simply pay them not to do something else. So imagine a farmer wants to grow wheat, and Congress says, no, we'll give you $1 million to grow cotton instead. Well, okay, if you're a farmer, you're going to take the free money. So even though Congress can't regulate what the farmers did, they tried to do it through spending money. And in Butler, the court held that this was unconstitutional. They invalidated this. They said the federal government cannot compel these farmers to take action through the payment of money. Okay. The dissent by Justice Harlan Fiske Stone, the guy with the Tea Party, right? The whispering in her ear. He said that courts should not be concerned with the wisdom of statutes. Congress should be able to spend whatever they want in pursuant to the general welfare. This is Felipe and Alexander Hamilton's idea, right? They should be able to spend whatever they damn well please. If Congress has money, who is a court to tell them not to spend it a certain way? So everyone get Butler. Now that case is really no longer good law. As most of the pre-New Deal cases, and this was a quasi-post-pre-New Deal case, it's no longer good law. And the reason why it's no longer good law is witnessed in the South Dakota v. Dole case, which we'll do in a minute. But simply put, because Congress can now regulate local farming, they don't need to use a spending power anymore. Because Congress can now regulate local activities, they don't need to use a taxing power anymore. Everyone understand? So you didn't actually need to overturn Drexel. You didn't need to overturn Butler. But as a consequence of Wickard and basically making the commerce power unlimited, Congress no longer needs to use the taxing and spending power for individuals. Why? Because Congress can directly regulate individual conduct within one state. Congress doesn't need to tax. They don't need to spend. They can just regulate the hell out of them and have penalties backing it up if they don't comply. Right? This is why when the Affordable Care Act was being debated, everyone in Congress said, oh my God, no, it's not a tax. We're not taxing people. It's a regulation of commerce. They said 100 times. The president said on national TV, it's a regulation of commerce. Why? Because who wants to raise taxes, right? No one. No one wants to raise taxes. So they said it's a regulation of commerce, and under the commerce power, they can penalize and basically get whatever they want without having to make you pay a tax. Questions? Questions on Butler on the spending power? No? Okay, I'll move on. So the next case we have to talk about is called South Dakota v. Dole. And no, this is not the Viagra spokesman Dole. It's actually his wife, Elizabeth, who later became a U.S. Senator from North Carolina. She was the Secretary of Transportation under President Reagan. Her husband, Bob Dole, was the longtime Kansas Senator who apparently is still kicking around. Okay. Where was I? Sheridan. Sheridan, what were the facts in Dole, please?
Basically, it was dealing with federal highway funds from the federal government, and they were saying that, well, overall, they wanted the drinking age to be over 21 years of age across the nation. And so they were saying that they were going to withhold some funds from states who did not reduce the drinking age.
Okay, good. So I guess I don't think anyone in this room was of the drinking age before 1986. Okay, so the drinking age throughout the United States used to be very inconsistent. Some places it was 21, some places it was 20, some places it was 19, some places it was 18. Indeed, we'll do a case from Oklahoma later this semester called Craig v. Boren, where the drinking age was different for men and women. Women could actually drink a certain type of light beer. You know what that is, the 3% beer. People were smirking. Yeah. Girls were allowed to drink that light beer before boys were. They were deemed more responsible, I suppose. The court invalidated that provision. People are nodding, but we'll do this case in about a month. The court found that was unconstitutional, that you couldn't impose such a gender-based stereotype. Funny?
Sorry, not
No comment. Although a couple people are asking us if you drink from the keg from the like, not a chance in hell. Not a chance in hell. No way. So the Congress said, okay, we have an idea, right? We want to make a national drinking age of 21. We don't want states to be able to have a 19 drinking age, 18, whatever it happens to be, right? You know, states can't do this. So Mirza, could Congress have passed a statute that said simply, every state, you are required to change your drinking age to 21, done, go, do it. Could Congress have enacted that statute?
Yes,
How?
they pass it in the House and they pass it in the Senate.
Would that statute be constitutional if it was enacted? Of course, Congress can enact any statute they want, right? If you get enough votes. Would that statute be constitutional?
Probably not.
What do you mean probably not? This is the crux of the case.
Not, that's not
Do you want to tell me why?
because, well, don't you have to like honor state? Like, I had trouble with this one, but like basically, you can't like use taxing or spending power to like coerce like state action.
I'm not talking about spending power. I'm saying the Congress passed a law saying every state must change their law to prohibit underage drinking under 21. Go.
That would coerce state action. So no, it's not constitutional.
Okay. Congress cannot make states do stuff. Okay. Congress cannot require states to take any action. Why? Federalism. Right? Federalism. States have their own sovereignty. And Congress cannot command, or to use a phrase we'll see later, commandeer. Congress cannot require states to enact laws. That would be unconstitutional. So Congress can't tell a state you're required to ban underage drinking. Congress can't tell a state you're required to move your state capital. Congress cannot require states to do anything. They can't. In the context of alcohol, this state sovereignty is even stronger because of an amendment that I'm sure all of you are well familiar with, the 21st Amendment. The 21st Amendment repealed prohibition. In fact, in Washington, D.C., there's actually a bar called the 21st Amendment. The 18th Amendment, as you may know, prohibited the importation of alcohol in the states. Ask yourself why we needed an amendment to ban alcohol, but not an amendment to ban drugs. Figure that one out for yourself. But the 21st Amendment says, 18th Amendment's repealed. Woo, right? Yeah, we can go partying, right? In fact, there's actually a holiday in D.C. where they celebrate Repeal Day. Everyone goes to the bar and drinks, which is not much different than every other day, but at least you have a constitutional reason to do so. It's true. Section 2 of the 21st Amendment says the transportation or importation into any state or possession of the United States for liquors in violation of the laws thereof is prohibited. What did this mean? Even though Congress repealed the federal ban on alcohol, states were still allowed to prohibit alcohol. And that is why we have dry counties. Anyone from a dry county? Yeah? Yeah? What county are you from? Where? Where? Kaufman County? Where?
Well, we just got it, but
Okay. So you figure Liberty County bans alcohol. That's very, very appropriate. The reason why there are dry counties is because of Section 2 of the 21st Amendment. I'm sure you all knew that. Interestingly enough, by the way, so for those of you who live in dry counties, on the county line, what is there always right on the county line on the other side of the county? So do you know why your counties are still dry? Because the liquor store on the border is paying to keep that ban in place. By keeping a ban in place in your county, they have a monopoly. They get a monopoly on that. You can talk about moonshine or what?
Actually, on Amtrak, every time the train enters a dry county, they have to close the bar.
I didn't know that.
They,
Well, it's
cross
faster.
out it. So you're like 2 o'clock in the afternoon, they're like, last call. And 20 minutes later, bar's open.
Wow. I mean, it's a federal entity, so they're required to. That's fascinating. So I want to actually give you a concept which you may have never heard of, and when we study economics, called the Baptists and the bootleggers. Anyone ever hear of this concept? Baptists and bootleggers. Anyone? Yeah, you want to tell us about it?
Well, I mean, not like we kind of use it, kind of tossing around like that. Because there's always that one side is more generic than the other group is.
It's actually the exact opposite.
weren't they the people who prohibition?
Who supports prohibition? Tell us. And why do both the Baptists and the bootleggers support prohibition? Tell us.
Well, the Baptist for religion and the movement for money.
Money. Exactly. Once alcohol is banned, who stands to gain the most? The bootleggers. Because they can charge whatever they want for Samuel's moonshine, right? They can jack up the monopoly rents. So the Baptists and bootleggers is an economic concept that whenever you have some sort of special interest law, there's always different groups that support it. There are the Baptists, the people with good, pure, warm intentions, right? And then you have the bootleggers saying, oh man, we're going to profit off this. This is going to be awesome, right? We'll just have our speakeasy. We'll, pour our moonshine in the bathtub, and we'll pay these damn taxes, right? When the Amtrak sails through, you have a guy in the Amtrak selling cans of beer. Right? People can't wait 20 minutes. So alcohol was a very interesting industry that's been regulated by the states in many different regards in light of the 21st Amendment. So without a doubt, Congress could not pass a law saying, hey, states, you are required to ban the sale of alcohol under the age of 21. That would have been a violation of not only federalism, but the 21st Amendment. So Congress said, okay, we're not going to straight up ban alcohol because we can't do that. Right? Instead, what did they do, Heidi? They couldn't ban it. What did Congress do instead?
They said they would give funding for federal highways.
Would they give funding? What would they do if someone failed?
They would hold it if they didn't have
So this was the racket, right? They couldn't make them do it, but Congress said, hey, states, you know that highway funding money we give you every year? To keep your roads paved and stuff? If you decide not to change your highway law, change your drinking law, that's cool. We're just going to hold out some money. Right? The money your own taxpayers pay to us, we won't give it back to you. Oh, right. All these other 49 states, they'll get all this awesome highway money, right? But because you don't want to, you won't get the money. We'll withhold, was it 5% of your highway funds? No problem, right? Do you, right? Do whatever you want, but we will not, we won't take them. We just won't give you some money. Lexus, was this constitutional? Could Congress withhold 5% of highway funds in order to, let's say, encourage states to raise their drinking age? Nudge, if you will. Okay. Why? Okay, so can Congress use their spending power, and actually their anti-spending power, because they're actually withholding money, right? Lexus, can Congress withhold money in order to, nudge states to take some action? Yes, okay. The court held, and Lexus is exactly right, the court held that this was a valid exercise of spending power. Even though there were strings attached, right? There were strings attached. If you didn't spend this money, you lose your highway funds, right? But that's fine, the court said. Okay? Now, the dispute between the majority opinion, Travis, the dispute between the majority opinion and the dissent of Justice O'Connor has to do with whether there was a connection, right? Travis, tell me, what is the connection between restricting highway funds and lowering the drinking age? What's the connection there?
Basically, the majority was saying that the highway fund, they were saying that they could regulate the age because of the drinking and driving was a problem.
Okay.
But O'Connor basically said that's a load of crap because essentially you're either over-regulating or under-regulating one way or another, because you're either over in the sense that you're targeting, I forgot which one it was, but either way, she said that you're targeting the age of drinking, but basically older people can drink still and it's no problem.
So exactly. So here's the question becomes one of what's called germaneness or relativeness, right? And the court identifies these 4 factors. Lawsuits love 4 factors. One of them actually matters is number 3, right? So the first factor is, are you spending in pursuit of general welfare? Duh, you always are. Okay. Second, did Congress state the condition clearly? Almost always the answer is yes. The 4th provision, is there some sort of independent constitutional bar? For example, if Congress says, hey, states, we want you to, to close down all the mosques. If you do that, we'll give you some money, right? Okay, that wouldn't work because it'd be a violation of the free exercise clause. So the third one is where the money's at. That's the one that actually matters. And the third condition is if it's unrelated to the federal interest. So the connection's this. Highway funds on the one hand, drinking age on the other. What is the link between them? Travis said correctly, there was a fear that if I'm in South Dakota where the drinking age is 19, and I live across the border in Iowa where the drinking age is 21, all these drunk Iowan teenagers will be storming across the border to get to the liquor store on the other side of the state line. And that will encourage drunk driving. Now, I don't mean to come back to you, Travis, but you call that a load of crap, to use your phrase. Why? I mean, make sure when you're in your bar exam, make sure you use that phrase. I'll get you the points, right? But why? I think the bars today as well, which are South Texas friends, some good vibes. Why was it a load of crap?
I mean, basically, she was saying was if it's targeting, if the national interest is targeting drunk driving, this only targets teenagers, and it only targets them. I forgot what the over regulation was. But basically, it doesn't target people that were driving, or it only targets people that are driving.
Right. Yeah. So I mean, you're exactly right. It's very selective, right? It's only targeting teenagers who drink and drive. It says nothing about teenagers who drink at home, right? Teenagers drink at home. And I think O'Connor's skeptical. Are we really going to have a problem where all these teenagers are flooding across state lines? I mean, for any of you who've gone to college, is there a difficulty of teenagers buying alcohol on any college campus? So by the way, I'm about to blow your minds. Raising the drinking age increased teenage drinking. What? Raising the drinking age increased teenage drinking in a couple of respects. So first of all, imagine an 18-year-old could drink. Where are they more likely to drink? In a bar or in some danky dormitory basement? In a bar. And when you drink in a bar, there's a bartender who can cut you off. And there are different mechanisms to make sure you don't go home drunk. But when you're drinking secretly in your basement, you have no such mechanisms. I'll give you one else. If you're a teenager, right, and you can only drink, beer at a party, you're going to drink the entire keg because you might not get it tomorrow. Well, if you can buy beer in a store, you'll buy a 6-pack and then you'll take your time with it. It actually increases binge drinking because there's a greater incentive to drink everything in front of you. Perversely, as most regulations act, perversely, this ban increased teenage drinking and made it more lethal. Most regulations have unintended consequences. Actually, a lot of science behind this. I'm not making this up, I swear. But this was actually an awful idea. So one of the best ways you can actually improve situations for teen drunk driving is to lower the drinking age so they can buy alcohol in normal channels. Because it serves as no barrier whatsoever to kids drinking. None. It actually is counterproductive. Yeah.
Why have they not lowered the
because it makes people feel good. Because if I try to explain logic to people, they say, "Oh, well, how could it be that lowering the drinking age will help teenagers?" I just explained it in 25 seconds. It's not very complicated, but people don't respond to logic very well. And also, Mother's Day is drunk driving and lobbyists and all that other garbage. But yeah, it's an awful idea. I mean, drunk driving is a terrible idea, but these laws actually increase the prevalence of teenagers doing dumb stuff. It increases it. It makes it worse. It's better for teenagers to drink in a bar than to have to binge drink in a basement somewhere. I don't think anyone would disagree with that. Anyway, I'm talking about a 20-year-old, so figures. It's true. And I can send you articles on this later if you like. All right. So any questions on that part, right? So O'Connor would be willing to impose, okay? O'Connor would be willing to impose this test saying the spending condition must relate to the thing you're trying to fix. And she says the connection, the nexus, if you will, between teenage drinking and highway funds is very weak. It's attenuated, if I can use a phrase. It's like, if the signal stretched out too long, it gets very weak. The signal is attenuated. The majority says, listen, we don't have to decide this, right? We don't have to decide this. There's a footnote about it. We'll simply say it's close enough for us. We're not worried. And the 10th Amendment serves as no bar because the states are free. Now, Dan, the court says that the states don't have a difficult choice, right? What can the states do if they don't like this condition? What's their option?
Well, clearly they can not enjoy the money.
Yeah.
Or they can comply.
Yeah.
Uh,
Does the majority opinion think it's a big deal if they simply turn down the money?
no.
Why is it not a big deal for them simply to turn down the money?
Well, they look at it as value. I think they quantify it 5%.
Yeah, Dan's exactly right. The court basically says, listen, we're talking about 5% here, right? That's not a lot of money. That's like a few potholes that don't get paved, right? I mean, I'm making this up, but it's a fairly small amount of money. However, the court said, however, at a certain point, quote, pressure turns into compulsion. At a certain point, pressure turns into compulsion, right? Taylor, what does that mean when pressure turns into compulsion?
It's changing from an incentive into punitive pressure. It's saying you're commanding this, you're regulating it directly instead of just saying, hey, here's a little something, we really want you to do this.
So what if instead of withholding 5%, they withheld 90%? Would that be much of a deal there?
No, they would take away their realistic offer.
Right. So we'll do this next week with Obamacare, but during the arguments in the case, there was this great moment. I think it was I don't know the Jack Benny show, and ever hear of it? It was an old TV show, and there was one skit where Jack Benny was the host, comedian, and a robber walks up to him, puts a gun in his back, and he says, "Your money or your life?" And no, Jack Benny's like, "Oh man, what do I do?" And then the robber goes, "Your money or your life?" And he's like, "I'm thinking about it." Right? I'm thinking about it. Well, which one are you going to do, your money or your life? Of course you'll give up your money, right? This is the analogy the Chief Justice used. It's like negotiating with a gun to your head. Maybe you may have a choice on paper, but the actual consequence of saying no to the federal government is so severe that you have no meaningful choice. Now, the court in South Dakota v. Dole identified this as a possibility, that it's possible you may reach the line of pressure turning to coercion. And it wasn't until NFIB versus Sebelius that the court said that Congress crossed the line with the Medicare expansion under the Affordable Care Act, which we'll read about next week. If you notice, I keep talking about Obamacare. It's not because I'm obsessed with it. I very well may be, but this is the crowning jewel of our federalism topic. It includes commerce power, spending power, taxing power, necessary and proper, broccoli, everything's in there. And it's really a crowning, using broccoli as a metaphor, a crowning achievement for you to study. So keep all these things in mind as you do your reading for next week. Okay? So any questions then on the Dole case? Any questions on the Dole? Oh, I'm sorry. Who's hand? Dan.
Well, quick question. The majority opinion pretty much kind of throws this white net and says, okay, as long as what you're asking to be done is not itself unconstitutional, or
Yeah.
But O'Connor acknowledges the 4-point test based on precedent. So why the disconnect? Why didn't the majority?
So the 4-factor test is really silly. The only thing that matters is number 3. Lawsons love 4-factor tests, right? They can, whether it's this and that. No. What matters is how close of a fit is necessary. Everything's in the general welfare, right? That's easy, right? Everything must be clear. That's easy. Mm-hmm. So the question becomes here is how close of a fit. So imagine instead of Congress withholding money for highway funds, Congress would withhold money for alcohol treatment, right? Say there's a federal program funding alcoholism. And Congress says, hey, unless you raise your drinking age, we won't fund your alcoholism treatment program. What do you think O'Connor would say to that?
Not related. Sure.
Not related?
Well, alcohol and highway funding?
No. Congress said, if you fail to raise your drinking age to 21, we will withhold money from your alcohol treatment program.
Oh.
That makes sense? Yeah?
Yeah, I could.
Yeah. So there's a close relationship there, right? Whereas Congress says, if you don't raise your drinking age to 21, we won't give you highway funds. Well, what's the connection there? It's much more, attenuated. It's a weak connection between the two.
No,
it's a weak fit, if you will. Like, they don't fit together.
What about this unconstitutional argument where it says that as long as it's not unconstitutional, it's okay?
Well, I mean, that's always true, right? Like, I gave the example. Congress cannot say, pass a law shutting down all the mosques in your state, or else we'll withhold your highway funds, right? Well, independent of whether there's a fit, states can't shut down, houses of worship. So I think that'd be the independent bar. That doesn't come up very often. But Dole, the majority at least, recognize that there is this point where pressure turns to coercion. And that becomes the center of the Affordable Care Act challenge we'll read about next class. So any more questions on Dole? Questions on Dole? Yes, sir.
How come the majority doesn't address the 21st Amendment?
They don't think it's relevant because, in their opinion, South Dakota remains free to keep the drinking age whatever they want it to be. They don't have to take the money, right? According to the majority, South Dakota is free to keep the drinking age whatever they want because withholding 5% of their highway funds is not coercive, so they can do whatever they want. There's no compulsion issue. Yeah, Justice Brennan, interestingly enough, dissented, saying the 21st Amendment prohibits this. He was a Federalist for the 21st Amendment, at least. Any other questions on Dole? Yes, sir.
Wouldn't withholding the money from them, doesn't that affect commerce in the economy? I mean, I know it's only 5%, but
Sure. Can Congress regulate commerce?
Yeah, that's what it seems like. They would be.
Well, let me ask you this one, all right? Let me ask you this. Is that Dylan? Colby. Oh, it's one off. Okay. Colby, let me ask you this question. Could Congress have just passed a statute saying drunk driving affects interstate commerce, therefore all states are required to lower the drinking age, or to raise the drinking age?
Well, they couldn't do this.
Why?
Because they were saying that this it doesn't deal with the commerce law.
This is why they need a spending power. This can't be straight up a commerce regulation. They need to use a spending power, which is, again, broader. They can do more through the spending power than they can do through commerce power. Understand?
Yeah, I understand. I feel like, though, that the tax itself kind of steps back from what their objective in the commerce. I know they're not using that in this situation.
Oh, they're accomplishing the exact same goal. You're right. Because they can't require states to do this, they bribe them. Right? This is the modern era, right? Congress cannot regulate education. They can't. That's purely a local matter. But they can say to states, hey, if you want to accept these millions of dollars, implement Common Core. Okay. And states can say, no, we don't want it, we want it, but that's their choice. Of course, if states turn down federal money for education, the state schools will go bankrupt. And there's a perverse aspect to all of this, hope you realize. The tax money that Congress is spending comes from the states. Right? So it's basically asking Congress to give back their own money. And if a governor decides not to bring back a state's own money, it's people who are paying money and getting nothing back for it, which is a political cost as well. This is why the income tax amendment was so significant to allow the federal government to tax the people and then redistribute that money as they saw fit to accomplish certain national ends. Other questions on Dole? No? Okay. Move on. So the next case is a fairly complicated case, not because the law is hard, but because the facts are hard and involve science, which makes law students get queasy. The case is called New York versus United States, a 1992 decision from Justice O'Connor. The fact involved was called low-level radiation, right? So this isn't talking about nuclear waste from a nuclear power plant. This is talking about very weak radioactive material. So if any of you have a watch that glows in the dark, a luminescent watch, if any of you have certain types of thermometers, if anyone has any kinds of certain detection devices, there's a little bit of radioactive material in them. You are, I'm sure you don't know this, but you're not allowed to throw that stuff in the trash because it can contaminate groundwater, it can, screw things up. So in the 1970s, 3 states implemented a special dumps, if you will, of where to dispose of this low-level radioactive waste. Unsurprisingly, other states did not want to do this. Why? Who the heck wants a radioactive dump in their backyard, right? You'll say this in property, the concept of NIMBY, not in my backyard. No one ever wants something bad in their neighborhood. So these 3 states started to become overwhelmed. It was Nevada, Washington, and South Carolina. And they were becoming overwhelmed with all this radioactive waste that other people were dumping in their state. And they said, listen, we're not going to be able to hold 47 other states worth of waste. We can't do this. So Congress attempted to remedy this problem in 2 different ways. So first, in 1980, Congress enacted a law that said, listen, hey, states, you can enter into agreements, into these compacts, right? And that way you can come together and agree to share this waste and build your own dumps. If a state fails to do this, there was no penalty. But they said, listen, we're Congress, we will let the states work this out. We trust you, states, that if we let you build these compacts to, get together and dispose of your waste, you'll figure it out. Unsurprisingly, it didn't work. Okay, what state would want to build their own waste dump when they can keep dumping in Nevada, right? Just send it to Nevada. And no offense to friends in Nevada, but there's plenty of land out there. Okay. So in 1985, Congress tried a different step. They said, okay, we tried to be nice. Let's get serious here. This is a big problem with all this radioactive waste. So in 1985, Congress enacted this policy that's fairly complicated. Okay. And there were 3 different kinds of incentives. 3 different kinds of ways to encourage states to find a way to dispose of this radioactive material. So the first one was not objectionable. This was what was called monetary incentives. They said, okay, you know what? Any state that accepts this will get extra money. Okay? The Secretary of Energy can pay money directly to states that, establish these dumps. Okay. There's no constitutional problem there at all. None. If Congress wants to spend money and reward states that accept this waste, they can do it. If Congress wants to tax states that don't, they can do it, right? There's no constitutional problem here. Okay. Another one said, if you fail to meet these deadlines, you have to pay higher fees to dump your waste. Again, no problem. It's an interstate commerce market. You're sending waste from one state to another. Congress can regulate the fees associated with it. So the first 2 provisions of this law, were unremarkable. It was the third provision that was serious. This was known as the take title provision. The take title provision. So imagine you're New York, right? And you have in your state a Timex watch factory, right? And they're making all these glow-in-the-dark, watches. And they have all this radioactive waste. And New York was not able to reach an agreement with another state, and they didn't build their own dump. Under the act, what happens? New York is required to take ownership of the waste. New York is required to take title of the waste. And oh, by the way, once New York takes ownership of the waste, they have to figure out where to bury it. They have to figure out how to manage it. They have to literally take it from the companies and figure out what to do with it. This was a serious burden on the states. But recall the background, right? Remember in 1980 they passed this first statute, letting the states try to do it without any incentives. Nothing happened. So then they said, okay, you know what? Enact this other statute, right? This will encourage us with some penalties to do it. So unsurprisingly, as soon as Congress enacts this bill, what happens? New York challenges in court. Indeed, this was mentioned in Justice White's dissent. New York wanted this law. People from New York encouraged this law. And the second Congress enacted it, they challenged it in court saying it was unconstitutional. Right? Chutzpah, right? They thought this would be a good way of respecting federalism, but it was immediately challenged in court. So New York, which generates a lot of waste, pushed for the enactment of this bill, and they challenged it in court. Everyone understand the facts, at least. Everyone understand how the take title provision works. It's a fairly complicated factual pattern. I think I reduced it as simplistically as I can. Okay, so Laura, what was New York's argument about why the take title provision was unconstitutional?
Well, they just said that it kind of went beyond what they were allowed to do because it wasn't making them do something, but it was making it to where they pretty much had to do it.
Making who do what? Use names.
Making New York deal with their waste,
Yes.
no matter what.
Yes. So this is what's called commandeering. Commandeering, right? The argument went that New York was being commandeered to take ownership, to take title of this radioactive waste. New York argued that this violates the 10th Amendment, that it violates the principles of federalism, because Congress could not instruct the states of what to do. And if you'll notice, this was different than Dole. This wasn't Congress saying, if you fail to dispose of this waste, we will withhold 5% of whatever funding. This was a different creature altogether. Congress was demanding, in fact, instructing the states to take ownership of this waste, to enact laws to provide for taking ownership, to build infrastructure so they can actually transport this waste, right? This wasn't just an idle threat. States were required to take very specific actions in order to facilitate the transportation and ownership of these materials. So this was giving a mandate to the states to do stuff. Okay? So now, Katie, before we get too far into this, what's the problem with Congress telling the states to get rid of this waste? I mean, this is a serious national problem. If all these states are, letting this waste pile up, we're gonna have these three-eyed fish blinking around. Like, I mean, what's the problem here?
Congress has the power to regulate the states, but not the power to tell them exactly what to do.
Why should they not have that power?
That would be like taking away separation of powers and also infringing on the states.
But what's the problem with infringing the states? The states here are doing something very stupid, right? They're letting all this waste build up, and they're going to hurt everyone. It's a national problem. Why is this problematic?
You take away the state's power, then they can never give it back.
Oh, but so what? States shouldn't have this power. It's dangerous to let them actually regulate radioactive waste. It's a national problem. Well, the Constitution is actually silent here, right? It doesn't say that. And this is what they said in the Darby case last week, that the 10th Amendment is but a truism, right? The court in Darby said last week that all the 10th Amendment says is whatever power is not given to the feds is reserved to the states. The New Deal court basically read federalism out of the Constitution. But the decisions we have today in New York, United States, in Printz, in Lopez, in Morrison, all of these cases happen within a 5 or 6 year span, right? You don't study ConLaw sequentially. I wish you did. But this was 1992. Lopez was 95. Printz was 96. Morrison, I think, was 2000. So basically in an 8 or 9 year span, we have all these cases that had a rededication to federalism. This is a period that's often called the Rehnquist Federalism Revolution, right? The Rehnquist Court's Federalism Revolution, where the court rededicated itself to the idea that states' rights actually matter. Think about it. In Lopez, the court said Congress cannot enact a law regulating guns in a school zone. That was beyond their power. In Morrison, the court said that Congress cannot regulate violence against women. Domestic violence is a local crime. In New York versus United States, we're studying now, the court said Congress cannot commandeer the states. In Printz, which we'll do in about half an hour, right? The court held you can't force sheriffs to run background checks on people. All of these cases had a consistent thread. Without overturning any New Deal precedents, right? Nothing was overturned. The court found ways to chisel and to carve out specific protections for states' rights and said to Congress, you can't go further. We let you go this far with the New Deal, no mas, right? Nothing else. But why, Sarah? What does the court explain in Justice O'Connor's opinion? Why is protecting states' rights so significant? What is her vantage point? What does the protection of states' rights accomplish? Why is that so significant?
If it doesn't go back to the taxing, how they have to tax their own with the state.
Sarah, let me ask you the question like this. Should it matter that the states agreed to this compromise, that even New York agreed to this compromise before this thing was enacted? Should that matter, according to Justice O'Connor? It should or should not?
It should not.
Why should it not matter? Why should it not matter that the states were willing to let the separation of powers fall apart? Why should it not matter?
Because it's between the states, not the federal and state.
But the states agreed. Why should it not matter? You're right. Why should it not matter that the states agreed to violate the separation of powers? What does Justice O'Connor say about this? Why should it not matter? Ashley, want to take a stab? Oh, we only want Ashley, one Luis today. Okay, we're at half strength. Ashley, why should it not matter that the states are willing to cede this power to the central government? Exactly, 100% right. 100% right. Justice O'Connor says that the separation of powers are not there to protect the states unto themselves, right? She writes the separation of powers is meant to protect individuals. It's meant to protect individual liberty. And the states cannot bargain away the liberty of their citizens. The states cannot bargain away the liberty of their citizens, even if they consent. Okay, now, Luis, where have we heard this before? Where have we heard this argument before that the states and the different branches of government can't agree to just give up the separation of powers? Where have we heard this before? Where do we have a situation where the president and Congress agreed to shift the powers? Anyone? What case?
Oh, what case? I was going to say the non-delegation doctrine.
What else? Different case. What case do we have where the Congress and president agreed to shift powers? Line item veto case. Exactly. New York versus Clinton v. New York. Line item veto case, right? Also involving New York. The Congress and the president said, okay, you know what? We're going to give the president his line item veto power. We're going to shift this power. You recall that Justice Kennedy's concurring opinion. Again, this is a 1996 case around the same time. Kennedy's concurring opinion says no. The different branches of government can't shift around the powers. Why? Because separation of powers is meant to protect individuals, not the government itself, not the states. Here, the states were willing to shift away their power. O'Connor says it makes no difference because federalism is meant to protect individuals and not the states by themselves. Okay? Everyone with me so far? So this is why federalism, the court says, is so important. It protects ultimately the freedoms of the individuals. You'll see this in NFIB next week as well. This recognition that what protects people is the separation of powers, and when you let those walls down, we don't know what's going to happen next. Everyone with me so far? All right, so Luis, and try this one. So explain to me, how does the court say that this take title provision amounts to commandeering? What's the argument there? Yeah. So unlike South Dakota v. Dole, where they simply withheld money, right? Said you can raise your drinking age, we'll take away 5%. Here, there was no choice. Here, the court, the majority says, you're simply forcing us to take title. You're forcing us to enact laws governing the handling of this material. We have to basically acquire infrastructure to transport the material. We have to provide places to actually dump it, even though our people don't want it. You are making us do something that we do not want to do. This is not merely an encouragement under the spending power. This is a mandate. And the court also raises another point, one about what's called political accountability. Political accountability, right? So, Rebecca, let me ask you this question. Let's say you're a resident of New York, right? And all of a sudden, the state starts building a nuclear waste dump in your backyard. Who are you going to be mad at? Who are you going to get really mad at if your state starts building this nuclear waste dump in your backyard? Are you going? But whose fault is it really? Which government? Are you going to be mad at Congress though if the states are building this dump? Do most people even recognize that it's Congress making them do this and not the local government? Yeah, Rebecca's right. This distorts political accountability. By requiring the states to take action, the people in the state will be mad at their local representatives. They'll have no idea that it's actually the fault of some guys in Washington. They'll have no idea. So what Connor says is distorts political accountability. Okay. Therefore, it's commandeering and violates the principles of federalism. The take title provision was unconstitutional. Any questions on the majority opinion? Any question just O'Connor's opinion? No? All right, Tariq, please. Can you tell us and describe Justice White's dissenting opinion? You have it? You have it? The dissenting opinion, please.
She's saying that this is.
No, the dissent by Justice White.
Yeah.
The he. Okay.
So he's saying that this impedes the national government from acting free among the states.
What does that mean to you?
So that means that it makes the national government unable to get involved when there is a violation to regulate the actions of the different states.
Yeah. So you recall that Justice White also dissented in INS v. Chadha, right? The line item veto case. And you recall we said that his dissent in the line item veto case was very functionalist. It was very, what can we do to make our government work better for us, right? What can we do to make government more efficient? He says, all right, so what, this line item veto? It doesn't really work. Congress likes it. The president likes it. Let's just let it be. He makes a very similar argument here. Justice White says, listen, there's a national problem. The states wanted this law. The states sought this law out, right? Congress could have used its spending power to encourage the states with money. Congress could have also used its commerce power to mandate how this waste should be handled. He says Congress was trying to be respectful of the states. We should not intervene. Okay. Jacob, what was Justice Stevens' dissent? What did he say in his dissent?
You talked about how he didn't see why compared to during the time of the war, how I think they preferred the draft and kind of made analogies to that, and where Congress has the power to do that, but they should also have the power to regulate water and radioactive waste, things of that. Yeah.
So Justice Stevens has an interesting opinion here. He basically says this commandeering doctrine, malarkey, right? It's bogus. There's no such thing. There's nothing in the Constitution, Stevens writes, that prevents Congress from instructing the states how to act. And he has a historical example. He says during the Articles of Confederation, the central government was allowed to instruct the states how to act. The Constitution was ratified to increase the power of the central government. So how can it be, Stevens writes, that a power they had under the Articles was quietly eliminated under the Constitution? Okay. He writes, nothing in the Constitution suggests that Congress cannot impose mandates on the states. The 10th Amendment says nothing about this. The structure of the Constitution says nothing about this. The central government can do whatever they want. States cannot resist it. Okay, questions then? Yes, sir.
So would this under this limitation?
Are you talking about the dissent here?
No, I'm not. I'm talking about Stevens dissent specifically, just the concept that it's so if there's been some kind of instruction of state conduct from the federal government, right? Does that always give the state, like a given state, the standing to sue?
Yes. Yes. If Congress tells the states to do something, they're able to sue. That's why New York v. United States was in court. They were required to take action of actually accepting this waste, which was an injury.
Do you have any idea about how many state petitions like actually go to SCOTUS, like regarding like, you know?
Well, because of this decision, Congress doesn't impose mandates anymore.
Okay.
They use their spending power to encourage states. Other questions on the New York case? Yeah, there are two cases. Don't get confused, right? Clinton v. New York was the line on a veto case, and New York v. United States was the take title commandeering case. Students always get them confused. They both involve New York. Actually, one was Clinton v. City of New York, and this is the State of New York, but people get them confused anyway, so try to keep them straight in your head. Okay, any questions then on New York? Okay. Our last case for today is a significant one called Printz v. United States. So the issue in New York involved commandeering of the states, right? Commandeering of the state government, making them take title of this waste. The issue in Printz involved commandeering of individuals, specifically individual executive branch officers of the states. So the background of this law, which you may or may not know, one of President Clinton's signature achievements in his first 2 years in office was the enactment of the Brady Act, which the Brady Handgun Violence Prevention Act, which imposed a number of gun control laws. In large measure, it was the enactment of this law that the Republicans gained the House in '94 and became quite unpopular. But one of the provisions of the Brady Act was to require background checks when a person buys a handgun from a federal firearm license, an FFL. So if you wanted to buy a handgun from a federal dealer, you were required to submit to a background check. Now, today there's something called the NICS, the National Instant Background Check System. You basically go to buy a gun at a gun store. They can submit your information, and it takes a few minutes to run a background check. It's not instant, but it's a few minutes. It's pretty close to instant, and they give you an answer right away. If the answer is yes, you buy it. If the answer is no, you have to wait, and there's an entire regime. But when this law was first enacted in the 90s, they did not have a database which allowed people to make these sort of instant checks. So Congress came up with this alternative. They said, okay, listen, we can't run this instant check. There's no database. So what we'll do is this. A person goes to a store to buy a gun. He fills out this form. At that point, the gun store gives this form to the CLEO, the Chief Law Enforcement Officer, the CLEO. Okay. At that point, the CLEO has 5 days to run a background check and determine if the person has any criminal history. Okay, the CLEO must make an effort to determine this in 5 days. He's not required to actually deny the purchase, but he's required to actually investigate the purchase. If the CLEO tells the person that you can't buy a gun, he's ineligible. And the sheriff then must provide a law enforcement statement saying, here's the reason why. Okay? And failure to comply with this was a crime. If the CLEOs refused to comply, the sheriffs in these towns could actually be prosecuted for a crime. Unsurprisingly, in certain parts of the country, this law is not very popular. I'm putting it really mildly. So we have here a couple sheriffs. I know this because I blogged about this years ago, and I got a Facebook request from them. So I'm actually friends with them now on Facebook. But these are the sheriffs. This is Sheriff Jay Printz from Ravalli County, Montana. His town is so small, he is both a sheriff and the coroner. He's there. This other guy is a Sheriff Richard Mack. He's the guy here in the uniform. And he was the sheriff from Graham County, Arizona. I'll tell you. So the case in your book is called Printz v. United States, right? And it involved the two sheriffs, Mack and Printz. Does anyone know why the case is called Printz and not Mack? Anyone know? This is going to be a funny story. So the reason why is when the Supreme Court hears two cases, the case is named after the one that was filed first, right, as a lower docket number. So Printz filed first, Mack filed second. So the case is called Printz. I got this very pathetic, this very pleading email from Sheriff Mack insisting that I refer to the case as Mack v. United States because under alphabetical order, his name ought to come first. Doesn't work like that. No go. Interestingly enough, Sheriff Mack has been in the news recently. He's the head of the, what else is it called? The Oath Keepers. It's a group of sheriffs who've been in Oregon and elsewhere in the Bundy Ranch promoting various causes. So he's been in the news recently. You can Google him. That's Sheriff Mack. Almost immediately after the Brady Act was enacted, oh, that's some pictures too. But yeah, this is Sheriff Mack. This is him with a smile on his face. This is actually Stephen Halbrook arguing the case. So for a brief period, Justice Scalia sported a beard. That didn't last very long. This is actually one of the few pictures of him with the beard on. There are not many pictures of this. This is Sheriff Printz. The guy looks like a sheriff. His barrels, his chest comes out 5 feet. This is a picture of him directing traffic. He sent me all these pictures, so I use them. I mean, here he is with a guy, and he's also a board member of the NRA. So the lurking issue in this case, though, this was not a Second Amendment case. Justice Thomas wrote about the Second Amendment. I think it was cut out of your book, unfortunately. This was not a Second Amendment case where they're imposing this federal regime. The reason why is that Heller was still years away. So instead of bringing this as a straight-up Second Amendment challenge, the NRA brought this as a federalism challenge, which was, again, smart. Right? The same way that the federal public defender in San Antonio knew to challenge the conviction, not on Second Amendment grounds, but on Commerce Clause grounds, here the lawyers decided, listen, we can get this on federalism grounds. Okay? I think that's the only other picture I have of him. Yeah. This is my favorite picture of him directing traffic. I don't know why, but it looks very, air traffic control style. So this goes up to the Supreme Court. And the question becomes, right? The question becomes, can Congress require Sheriff Jay Printz to run a background check on someone and deny them the power to buy a gun? Now, I've spoken with Sheriff Printz. There is not a chance in hell that you've ever complied with this law. Had this law been actually enforced, there would have been massive civil disobedience. I don't say this lightly. Massive in Ravalli County, Montana, there would have been no one who would ever even comply with this law. And this raises an interesting question, right? Instead of Congress commandeering these local officials, they could have just sent ATF agents into every city in the country and stationed an ATF agent in every single county in the country. What do you think would have been worse? Stationing a federal agent doing gun background checks or letting your local guy run the background checks? So, I mean, at least in theory, you could think Congress saying, okay, this is not as bad as sending a federal agent into Ravalli County, Montana and ask people about their guns, right? At least they know this guy. He's our local sheriff. He's our coroner from life till death. He's got him. It sounds like a good idea. But on the flip side, there's no chance in hell that Sheriff Printz would have done anything at all with this law. Nothing. And good luck enforcing him. Good luck with the jury convicting him either. It would not have happened. I mean, for those of you not from Texas, I'm not, but I adopted it. Guns are important in many parts of this country. And this would have been very bad if they ever tried enforcing this law. Okay? So a lawsuit was brought, and they claim that this amounts to commandeering. So the first major challenge, of course, we have to, Catherine D, is in Printz. They only discuss commandeering of the states. Here, the states are not required to do anything. It's these local sheriffs. How does Justice Scalia bridge that gap between commandeering of the states and commandeering of the individuals? Okay, but Catherine, let me ask you a follow-up question. This is a point Justice Stevens raises in dissent. Congress can regulate individuals. Congress can use the draft. I think someone mentioned that before. Congress can require individuals to take action. Why can't Congress simply just tell state officials what to do? What's the principle underlying that?
I guess the sense of
Maybe. Catherine E. Why, if Congress can commandeer men and perhaps women into the draft, right? Why can't they require these sheriffs for these background checks? Right? Why are individuals suddenly cloaked with this shield the second they have a state office? What do you think? Yeah. What Congress can take a regular guy off the street, 18-year-old, throw him in an army, send him overseas to go fight. Why can't they make Mr. Printz, Sheriff Printz, run a background check on some guy? What's the difference here?
Well, isn't he like operating in the state as an official of the state?
Good. Want to try Catherine again?
Is it relating back to the presidential executive power?
Oh. So let's look at the Constitution for a second, right? I always take you back here with the answers issue here. If you go to Article 6, this is what's called the Oath Clause of Article 6. It says, the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers of the United States and of the states shall be bound by oath or affirmation to support the Constitution. So it says here, look, all state officials are bound by oath to support the Constitution. Zach, why isn't the answer right there? Why isn't that the answer? They're bound by oath to support the Constitution. Why can't Congress make them do stuff? Why can't they? I mean, that's Scalia held they can't. How do we look at this? They're bound to support the Constitution. It says it right there.
He said because they were acting as state agents of the states.
But aren't they bound by the oath of the Constitution? Right there. They're bound. What do you think? This is a tricky one. Anyone I'm looking for?
It's because the Constitution establishes federalism, and
Good.
the act here is a federal act, and they're getting
Good.
they're commanding agents of the state to take an action on behalf of the federal government.
Good. What else?
This is a good case to execute orders and just make it the executive power, but the Congress.
This is the state executive branch, not the federal executive. Anyone else? Yeah. Oh, good. Very good. So if you read the first part of Article 6, the Supremacy Clause, right? The most important provision in the entire Constitution. Most important provision by far. It says the Constitution and laws of the United States, blah, 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 shall be the supreme law of the land, and the judges in every state shall be bound. Look at this again. The officials of the state are bound to support the Constitution, just the Constitution. Judges are bound by the laws of the United States. Look at that. Look at that, huh? That every state executive branch official is bound by the U.S. Constitution, but not the laws of Congress. In contrast, the judges are bound by the Constitution and the laws. The judges are bound by the Brady Handgun Violence Whatever Act, right? But state officials are not. Right there. Scalia doesn't make this big of a fuss, but it's actually a pretty good textual argument. I mean, we can go to precedent in a minute. But it's the case that judges are bound by the laws. And it makes sense for judges to be bound by the laws. Why? Because you can bring a federal cause of action in state court. You studied this in Civ Pro. You can bring a federal cause of action in state courts. State courts are required to enforce federal law, with some caveats. State courts are required to enforce whatever law is brought to you. Scalia calls them transitory, right? The court applies the law of the case. In contrast, Scalia says, state executive branch officials, Sheriff, Printz, he is not bound by federal law. He's not bound to do stuff. And he cannot be made to take action under federal law. Right? Because he's an officer of the state. And even individuals can be drafted. Here, because he's operating under the authority of state office, he's given a special dispensation. So everyone get to the textual part, right? There's actually, I mean, this is not, but I don't mean to pretend this is a 100% argument, right? But the text at least does seem to draw a distinction between state judges who are bound by law and Constitution with state executive branch officials who are bound only by the Constitution itself and not by laws. Yeah, Tariq.
Okay, I don't understand how can apply this with the Constitution is the supreme law of the land. So how can he follow the state law only if the Constitution is the higher law?
What Printz is saying is not that he can ignore federal law. He's simply saying you can't make me enforce it. Printz is not saying that he can disregard federal law. He's not saying, I'm going to start selling, illegal guns to everyone I want. He's simply saying you can't make me a part of your regulatory regime. You can't make me part, right? You can't bind me to enforce your law. This is only something that the central government can do.
So, federal district court in that area.
Well, the state judge, the state, what you mean?
No, well, that's my question is that whether or not what would happen if like a federal judge had a law, made a decision, and it was bound in that same district of states, and it was about a state official, or what the role. So you say that a judge in a federal district not like rule or have a holding on a state official?
No. All I'm saying, all that Justice Scalia is saying, this is not what I'm saying. All that Justice Scalia is saying is that state officials can't be bound to execute and enforce federal law. They can be obligated to follow it. So, for example, if Sheriff Printz started selling illegal guns, right? He could be charged in violation of federal gun laws, but he can't be charged with enforcing federal laws. See the difference? Samuel?
So it's like in Colorado where the local cops aren't enforcing federal laws.
Oh, so glad you asked me about that. So, it's like this. So, has anyone heard the phrase of a sanctuary city? Okay, a sanctuary city. This is actually a very interesting application of the commandeering doctrine. Can states require, can Congress require the states to enforce federal immigration law? See, this is where people get flipped up. They may not like guns, they like sanctuary cities, they may not like guns, this flips everyone up, right? The same principle under which Sheriff Printz will not enforce federal gun laws, Congress cannot force San Francisco to enforce federal immigration law. Whoa, I just blew your mind, right? This usually scrambles people. The same principle by which Sheriff Printz cannot be forced to enforce gun laws, the city of San Francisco cannot be required to enforce immigration laws. And this usually takes a form like this. What if a person who's here illegally gets arrested for, whatever, theft or something trivial, right? The Homeland Security Department says, hey, we want you to tell us if you have anyone in your prisons who are not here illegally. We want you to tell us. Under the doctrine of Printz, San Francisco, I'm not just picking on them, they have one of the more prominent ones. Houston has one as well. San Francisco is not required to turn over anyone there the feds want. They're not required to. It's so ironic because most of the people who support sanctuary cities want nothing to do with guns. They'll hate Printz until they realize it can be useful for this. The cognitive dissonance is beautiful. But the same principle applies. Indeed, there was actually a proposal in New York where New York said, even if there's a court order to turn over an alien, we will disregard it unless we deem it to be a dangerous felony, right? That was probably unconstitutional. I don't think the states can ignore judges. I think they can ignore Congress. But the flip side is there's federal money involved. In fact, today I read an article saying that the Justice Department says if states refuse to turn over people that we want, we'll withhold funding. Oh. So here again, you can't require states to enforce federal law, but you can withhold funding to nudge them in the right direction. So everything always goes back to the spending power. Every state receives lots of money, lots of federal grants, and there's nothing stopping Congress from withholding a certain chunk of that to induce states to comply with federal detainers, the federal orders. But it's a fascinating application. So Samuel mentioned Colorado. Okay. In Colorado, the people voted to legalize pot. I was in Denver a couple weeks ago. You can smell it. It's awful, right? Or depending who you ask, I don't know. I don't like it. So I hate San Francisco for that reason. Anyway. Can the federal government require a Denver police officer to arrest someone for smoking pot? Samuel? Absolutely not. The U.S. government cannot require a Denver police officer from arresting someone for smoking pot. They can send an FBI agent or a drug enforcement agent to Denver and arrest the entire town of people smoking pot. That's not a problem. But they can't force the state to do it themselves. And as it actually turned out, right? As it actually turned out, the federal government doesn't enforce drug laws there either, which I think raises other problems because if the states won't do it and the feds won't do it, then you have a serious issue. Okay? So Scalia's analysis then takes you through and effectively says it's unconstitutional to commandeer the people. You cannot commandeer individual executive branch officers. Okay. All right. Any question then on Justice Scalia's majority opinion? Okay. I want to. Who's laughing? Is that next to us? She's having a good time in there. I want to focus on one aspect of Justice Scalia's analysis. He discusses the necessary and proper clause. And there's a discussion of whether, think of it like this. Congress enacted this gun law, right? And Congress said, we want to restrict people with felonies from buying guns. Okay. Assuming that violates the Second Amendment or whatever, it doesn't matter, put that aside for now. That's a regulation of commerce, right? People are buying guns sale, commerce. We studied in McCullough, Maryland, the idea that we understand the necessary part of necessary and proper to be convenient, right? Is it convenient to Congress to require Sheriff Printz to run the background check instead of Congress building their own federal regime? Is that convenient under McCullough? Yeah, it makes their life easier. They can have Sheriff Printz do it, and they don't have to do it themselves. But what Scalia hints at in Printz, and becomes a very important aspect of the Obamacare decision next week, is not just whether something is necessary, but whether it's proper. Scalia breaks it apart and says something very well may be necessary, but it's not proper. And why is it not proper? Because it violates state sovereignty. Scalia says a law that intrudes on states' rights in this manner cannot be proper. You'll see next week in the reading with the Affordable Care Act, the Chief Justice effectively says, mandating that people buy insurance might be convenient, might be necessary for the ACA to work, but it is not proper to intrude upon individuals in the states by mandating this. So what Printz started, you'll see it next week in the Obamacare case, is separate necessary and proper. Okay. Questions on the majority opinion? Questions on the majority opinion by Scalia? No? All right, let's talk about the dissent by Justice Stevens. Justice Stevens and Justice Scalia were frequent sparring partners. They would often go after each other. Usually Scalia was in dissent and Stevens in the majority, more often than not. But Justice Stevens, again, as he noted in the New York case, doesn't believe a commandeering doctrine even exists. He says during times of war, right, the president has instructed local officials to help with the drafts, has instructed local officials to be wardens for air raids, other things like this. To this, there's a response by Justice Scalia. These were all requests. In every instance where the executive branch told state officials to do something, they weren't actually telling them, they were making a request. I think Scalia is probably more correct about this, but Stevens has a strong enough point that they weren't framed as requests. They were framed as orders. States perhaps could have refused, but they did not. And Stevens effectively charges Scalia with making this doctrine up out of a whole cloth. The only problem, though, for Stephen is the text of the Supremacy Clause. The text of the Supremacy Clause rebuts his entire argument. And you know how I know this? A couple years ago, Justice Stevens wrote a book called 6 Amendments. 6 amendments to change the Constitution. Okay? Do you know what one of the amendments was? I'm paraphrasing here, right? One of the amendments was, shall be the supreme law of the land, and the judges and everyone else shall be bound thereby. If anyone wants to Google it, I can't remember the exact phrasing. But he effectively said, all state officials are bound. How would Stevens amend the Constitution? Binding all state judges. So I can find it. It will come up in a minute. So Stevens, if he can amend the Constitution, here we go. All right, I know I had this one last year. Go. Yeah, I actually got a review copy. It wasn't a very good book. Okay, here it is. It wasn't good. So there it is. It's hard to read, but I'll read it aloud. This Constitution and laws of the United States, blah, 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 shall be the supreme law of the land, and the judges and other public officials in every state shall be bound thereby. So Stevens acknowledges that the text of the Constitution is an impediment to his position. So he would seek to amend the Constitution to make not just judges bound, but all public officials bound. Dan?
Doesn't that in turn make a state public official a direct agent of the federal government?
And that's exactly what Justice Stevens wants. He sees there's no problem with state officials being the agents of the federal government. No problem whatsoever. None.
So then would the executive branch of the federal government participate in any appointments? Or it convolutes quite a bit.
Yes. Yes. You can read Justice Stevens' book. I mean, it's not very, I didn't like it. It was, I think there's something, so by the way, he's not actually a retired justice, right? Technically, he can still sit and hear cases, although Justice Stevens never actually heard a case since he stepped down from the active duty. But he's still actually a justice. He keeps a chamber at the Supreme Court. He has a law clerk paid by taxpayer dollars. I think if he wants to go and write books, he should resign and, collect his pension and be a public citizen. But while he's still in the court and still a justice, I think it's inappropriate for him to keep writing books saying how we should change the Constitution. I think it's untoward. But they don't listen to me, so I have no say. Yes, sir.
On that point, so could Justice Stevens just take Scalia's empty seat now? I mean, not take it, but you walk in, sit on the court, and become the Knight of Justice?
So the short answer, right? The short answer is no. So when Justice Stevens stepped down, he didn't actually step down, but he said he was taking senior status. And what that means is he can keep a chamber at the Supreme Court, and he gets a law clerk paid for by taxpayer dollars. However, he's not eligible to sit on Supreme Court cases. Now, there was actually a proposal about 3 or 4 years ago from Senator Patrick Leahy of Vermont that said in the case of a recusal where there were one justice short, one of the senior associate justices could sit. Thankfully, that went nowhere. But no, Justice Stevens cannot waltz in and sit. I had a scary thought on the day that Justice Scalia died. I mentioned the recess appointment thing. I was like, oh, he's going to recess appoint O'Connor. I knew it. I had this image that blared through my mind, but he did not do that. Okay, other questions? All right, so what did we do today, right? We did a lot today. We actually covered a lot of ground. We have the taxing power, where effectively Congress can tax just about anything they want, so long as it's not a penalty. We have the spending power. Congress can spend money any way it wants on the states, so long as it's not coercive. And we have the commandeering doctrine. Congress cannot commandeer the states to enact laws, nor can Congress commandeer individuals. All of this is building up to the Affordable Care Act case. And I want you to take great care when you read this next week. The Affordable Care Act, as understood by the majority opinion, mandated people purchase insurance. Failure to do so requires payment of a penalty. This case implicates the power of taxing, the power of regulating commerce, the necessary and proper power, and indeed the commandeering of the people to make them buy health insurance. The second aspect of the ACA, which maybe I'm less familiar with, is the Medicaid expansion, which told states to increase the number of people who are receiving government-provided insurance. Failure to do so would require the forfeiture of 100% of the state's Medicaid budget. It was in this case the court finally found the limit identified in South Dakota v. Dole, at which pressure turned into coercion. The NFIB case is probably one of the most important cases you'll read this year. And I also included a segment from the book I wrote for free. You don't have to buy it. You're welcome. Some professors make their students buy their books. I don't like that. So you can buy it if you want, but I get it for free. And you'll learn a lot next week. So thank you very much. Have a great night. Have a good weekend. I'll see you next time.